We have breaking news out of the election fight involving Elon Musk and his ongoing efforts to get people to sign petitions that show their support for the First Amendment right to free speech, and from our point of view, the most important right, the right to keep and bear arms. Let's break down what just occurred with a judicial activist federal judge in the city of Philadelphia and why, at the end of the day, it's actually not going to matter, and that's good news. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Down, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed, What the 10/7 Attack on Israel Teaches We Americans About the Right to Bear Arms. All right, folks, so we have breaking news. Yesterday I did a video explaining a big win for the Second Amendment and Elon Musk by virtue of his removal of the case by the district attorney, Larry Krasner, the district attorney for Philadelphia, against Elon Musk and his America PAC. By removing this case to federal court, he thwarted the ability of the Philadelphia district attorney and a state court judge to force Elon Musk into a state court in Philadelphia, taking him off the campaign trail and likely trying to thwart his ability to continue his petition drive and his awarding of $1 million a day to people that signed the petition showing their support for the right to keep and bear arms and the right to free speech. Now, there is breaking news here, and that is this. Federal District Court Judge Gerald Papert, a President Obama appointee to the federal bench, has rushed through briefing on the question of whether or not this case against Elon Musk should be in federal court or should be in state court, by having expedited briefing overnight, and has just decided this case should be sent back to state court. Now, this is absurd for several reasons, but I just want to focus on the practical realities of this because that's what I care about, and that is this. The practical reality is this maneuvering by Elon Musk and his lawyers to remove this case from state court to federal court has already proven to be a big win for Elon Musk and his organization, America PAC. And why do I say that? It's because, remember, in every litigation, this is something you should keep note of. Always remember this, not just for this case, but all the cases we talk about, because it explains a lot of motives and conduct of how people behave in the context of legal cases. And that is this. One party likes the status quo, doesn't want to change the status quo, want to keep the status quo going. The other party inevitably wants to change the status quo. For example, if you're sued for money, you like the status quo, which means you get to keep your money. The other side wants to move to change the status quo by taking your money away from you so they can have it. Here, and this is why you got to understand that in this context of Elon Musk, here Elon Musk was getting people to sign a petition supporting the right to keep and bear arms and the right to free speech, and was giving away $1 million a day. And here's the key. Up until Election Day. Up until Tuesday, this coming Tuesday, Election Day. Which means, from a practical point of view, in the real world of litigation, not some airy-fairy theoretical world, but in the real practical world of winning and losing cases and winning and losing political fights, the reality is Elon Musk and his attorneys, from my point of view, in my opinion, simply just needed to keep the ability to continue the petition drive going and the awarding of $1 million a day going until Tuesday, Election Day. Because they removed this case to federal court on Thursday, thwarting the ability of a Pennsylvania state court to get involved, even though this federal district court judge on an expedited basis, and it seems to me this briefing schedule was inappropriate. There's no reason for there to be an expedited briefing in this particular case. And the fact that this Obama judge, Gerald Papert, sent this back down so fast to the state court, having made a decision on the removal, meaning the removal to federal court, he has now ordered the remanded back to state court, really speaks of judicial activism, in my opinion, because there's no excuse whatsoever in this context for the judge to expedite the briefing as opposed to hearing the arguments in the normal course and maybe even have an oral argument on the matter. But the fact that this judge sort of went out of his way to speed this along so fast and send it back in a matter of hours speaks to a political agenda, I think, that should not be there. But again, maybe I'm wrong. That's just the impression I get. Because remember, the judicial system is not just about having a fair process, not just about being fair. It's equally important for our judicial system to appear fair to the public, to make sure that we trust and give credence to their judgments and decisions. And I think speeding this along and sending this case back so quickly to state court does not appear fair to me. And I don't think it appears fair to others. But again, the point being, and this is the fundamental takeaway of this, even though a possible liberal judicial activist, Gerald Papert, Obama judge, sent this back to state court, it may not practically matter. And all of this is a huge win for Elon Musk either way, because again, the status quo of Elon Musk getting people to sign his petition in favor of the right to keep and bear arms and the right to free speech continues right now. It's not stopped. And likewise, the ability to give out $1 million a day under what he's been doing continues as well. So it is very good news from Elon Musk and his America PAC organization that the status quo continues. And by removing this case to federal court on Thursday and litigating this over the last couple of days, and now, of course, we're into the weekend. I'm not saying judges can't act, but it's unlikely to see a state court judge in this case, rush around on the weekend. I'm not even sure that's physically possible, set aside other issues that may pop up. And again, the good news is, no matter what happens ultimately in the merits of this case, Elon Musk, in my view, has already won the matter because he's able to continue what he wants to do, which is to maintain the status quo of getting people to sign the petition and to give out this money, $1 million a day. But just by way of making an observation, just because I think for those of you who are interested, this was the argument that Elon Musk's lawyer made to the Obama appointee judge, Gerald Papert, by arguing that this case is really appropriate for federal court because really what you have here is the district attorney, Larry Krasner, is trying to inject himself as a state actor, meaning the state of Pennsylvania actor, set aside if he's acting for Philadelphia or the Pennsylvania, but he's really injecting a state issue into a federal, hear what I just said, a federal election, which is governed by, listen carefully, federal law, the federal Constitution, the Federal Elections Commission. See, the word federal is in there quite a bit. So you're not supposed to have states getting too involved in this sort of thing when you're messing around with campaign finance rules under federal law. And keep in mind that the U.S. Constitution has what's known as the Supremacy Clause of the U.S. Constitution. This says if there's a conflict between federal law on the one hand and state law, which is what Larry Krasner has sued Elon Musk under, state law, specifically state laws involving alleged lotteries, state laws involving consumer deception and the like. He is essentially, as best I can tell, trying to use Pennsylvania state laws to interfere with Elon Musk and his PAC's ability to operate in the context of a federal election. You're not supposed to allow state laws and state actors to interfere with the federal process and federal elections because there's federal officials such as the Federal Department of Justice, federal judges, federal courts, and the like, Federal Election Commission officials and the like, and the Department of Justice can all step in and regulate and govern issues associated with federal elections. So with that in mind, let's just quickly look at a critical argument made by Elon Musk's attorneys against the process of Larry Krasner and this federal judge sending it back down to state court. Here's what they said in favor of keeping the case in federal court, which I think was a pretty good argument. Taking District Attorney Larry Krasner at his own word, that much is abundantly clear from the face of the complaint. Plaintiff, meaning the city of Philadelphia and District Attorney Krasner on behalf of the state allegedly, plaintiff is seeking emergency relief which in and of itself would require judicial intervention into the progress of an ongoing federal election. This, however, a state court cannot do. The issue of whether a federal political action committee like America PAC, which is focused on making independent expenditures to influence campaigns for federal office, not state or local offices, is exclusively governed by federal law and the First Amendment to the United States Constitution. Indeed, Congress has clearly vested the Federal Election Commission with the exclusive authority to regulate federal elections, and then it cites to various federal laws. That's powerful points that Elon Musk's attorneys were making, and they continued on explaining why this case really needs to be in federal court, given the fact that all these issues arise from a federal election and federal law and federal expenditures in a federal election, in a federal case, and so on. Nevertheless, the Obama appointee judge has sent this back to state court. But see what else Musk's attorneys made in terms of their argument, which I thought was pretty good. Removal here is proper because a quintessential question of federal law is inextricably intertwined in the district attorney's manufactured and phony emergency. Indeed, in his effort to convince the state court that a preliminary injunction must be granted on an urgent basis, paragraph 8 of district attorney's complaint the district attorney's complaint, paragraph 8 of his complaint firmly embraces federal law and jurisdiction by tying himself to the November 5th, 2024 general election for President of the United States, and by connecting the purported illegal conduct to be restrained to a political effort that was and is in connection with a federal election. The district attorney's real intentions are laid bare. The lawsuit manifests his desire to obtain a prior restraint of core political speech protected by federal election law and the First Amendment, because the district attorney personally disagrees with the speaker. And then he goes on to say, the district attorney wants this litigation to be a rushed stage play and the attendant spectacle and attention that go with it. But this lawsuit belongs in federal court where it can be decided soberly and in a deliberate fashion. The district attorney's motion to remand should be denied. So there you have it, folks. Notwithstanding those arguments by Elon Musk's attorney, the federal district court judge appointed to the bench by Barack Obama has sent this case back down to state court. But as I explained to you, as a practical matter in the real world, which is what I am concerned with, not the theoretical world, the real world, as a practical matter, Elon Musk has already won this case because he's not going to be thwarted in any kind of timely way that's going to prevent him from doing what he wants to do, which is to get these petitions in favor of the Second Amendment and the First Amendment signed by petitioners and continue to give away $1 million a day until Election Day, which is just a couple days away. So smart maneuvering by Elon Musk's attorney. I still think the federal district court judge was a little sloppy and rushed in his decision to remand this so quickly. Nevertheless, it probably will not matter in the real world, and I will keep you abreast of this as it continues. But again, a big win for the Second Amendment and that Second Amendment petition, who continues to move, Elon Musk continues to move the Overton window of the Second Amendment in favor of a right to keep and bear arms. And it's very good that he bought X and is doing what he's doing. It's great to show millions and millions of Americans of the importance of the right to keep and bear arms, because Elon Musk has a very powerful and broad microphone, even bigger than the Four Boxes Diner, believe it or not. And Elon Musk is doing a great job explaining the importance of not just the right to free speech, but of course the right to bear arms. All right, folks, hope you learned something here today at the Four Boxes Diner. Make sure you follow me on X at Four Boxes Diner. Don't forget to like this video and subscribe. We're trying to grow the channel and hit 200,000 subscribers. We're working hard to get there, and we look forward to seeing you again very soon here at the Four Boxes Diner.
Orders up. Table 2A.